Okay, it is about 8:31 p.m. and it is Monday, May 4th, 2020. Welcome to week number 5. Week number 5, guys. The quarter will be over, and next week will be the last lecture, and the quarter will end soon. And so you guys been dealing with this sh- lockdown, shut in, COVID-19. One of the things that I want to share with you all that I'm doing is I'm involved um, with a course that I am taking, and the hold on a second. Let me see if I can pull it up. Um, see if I can do it. Give me a minute. Okay. Yeah. Okay. Good. I can share it with you. I've been taking a class from my alma mater at Northwestern University, and it's a very interesting course. I think this is it. Yep. So you guys can see that I just this last week completed week 1 of this course. The course is entitled "Law in the Times of COVID-19: A Northwestern Teach Out," and then last week I dealt with topics of public health mitigation, government, federal, state, and local responses. And these are just some of the things. I won't show you the whole thing, but those of you see check marks, that's everything I did this past week. Civil liberties in the court, and dealing with the travel and everything. And so this is going to be a really nice course for me that I'm able to learn more. This week, we'll be starting with regulation and civil liberties, continuing. And then we got legal issues in public health. And then there's some more things coming. And all the way down to week 3, legal duties and liability. And then week 4, what I call my ice cream, criminal justice and society's most vulnerable. I'll be talking about that. Unfortunately, you guys won't. I'll be finished with the course by the time that you um, I have gotten to this point. But it's a very interesting course. I'm learning quite a bit about what is going on with COVID-19 and the law. And it's interesting because it fits within the context of constitutional law. Uh, Here is an article that I want to share with you guys. Let's see, I'll go back to the classroom. I have to stop sharing to show it to you. Excuse me. So this right here, I'm going to click on it, and you guys see this article? Can you see it? Type in the chat box. Yes, no. Can you see it? Anyway, did you guys see the article? Okay, let me do it like this. Okay, you can click on the link yourself, the link that I have there, and that is for you guys. You can take a look at that a little later. But anyway, what has happened is that there was a lawsuit that was filed in Illinois by a pastor of a church, and let's see, I don't know why. I guess it's because, okay, yeah, okay. Let me see if I can get back to it. Let me see. Okay, so you see me, and let's see if I can do this. Let's see if I can do this. Do it like this, and this will help you see it. Let's do it this way. Okay, I think you'll see it. You see it now? Can you see it now? See it now? Did you see it? Hmm? Okay. Oh, I know why. Duh. You're right. Okay. Now you see it. Now you see it, don't you? Okay. Well, anyway, here's what happened. This is a very interesting case where the United States District Court uh, ruled. The governor is Pritzker. That's our governor, and this deals with this deals with some the constitutional law issue here. That in the constitutional law class says that the stay-at-home orders are constitutional, and I understand that based upon that Northwestern class that I'm taking. But what happened is that the pastor of a church filed a temporary restraining order that would have allowed them to host 80 people or more. Well, the rule is stay at home is 10 for the safety of people. You all kind of know a little bit about that. Well, the court issued a ruling upholding the governor's stay at home order. And so this church is located about 50 miles west of Rockford. Some of my students probably might know where this church is from out in the Rockford area. But he filed a complaint Thursday, and I don't know if I can get the complaint in or not. Let's see. Yeah, he sued. Let's get that out of there. He sued for the stay-at-home order, and He said that um, the plaintiffs believe that in these times that we need the Spirit of God, and says that it's a violation of the First Amendment and dealing with freedom of religion. And that was what he was saying. Well, the court said no, that's not true. So when he filed the complaint, and so he wanted to hold the service Sunday, and if he was going to hold it, he would be violating the law and could be arrested. But given the threat uh, posed by COVID-19, the order preserves the avenues for praise, prayer, and fellowship and passes constitutional muster. And it's a 37-page decision. I'm trying to get a copy of it. Now, in this case, it's very interesting. They cited two historical cases, Jacob versus Massachusetts and Prince versus Massachusetts. These are cases that I studied this past week in my class that I'm taking on COVID-19. And it's very interesting. So, which said that a community has the right to protect itself against an epidemic disease and the right to practice religion freely does not include liberty to expose the community to communicable disease. That's it in a nutshell, guys. And it's a very interesting thing to watch out for. And, there is also a second lawsuit, which I'm not going to talk about, where there are two legislators who are seeking to overturn the ruling of the governor. And as you all know, each of your states you're in, governors are the ones who are issuing the stay-at-home orders. And so what is happening here is people are trying to challenge this. And like I said, we have two legislators um, here in Illinois. But it's a very interesting topic for somebody to do some research on COVID-19 and the Constitution, and so it's a very interesting topic. So I wanted to share that with you. Again, what you can do is you can go to this link, the link that I put in here, just right here, and then it will take you to the article that I just had, so you can uh, download it and then save it. So I thought that would be something that would be interesting to my students that are in this class, because it involves constitutional law, and it shows you how the Constitution is involved in what's happening with COVID-19. I am a student of the law, and so you'll learn stuff from me that you won't hear from other professors. So anyway, I wanted to share that with you. So let's get right into our module. Let's jump right into, okay, let's see, that's screen number 1. That's Skype. Which one do I want to do? Nope, that's, okay, I got to take that down. Here we go. Okay. You guys with me on the course homepage now? Can you see it? Okay, great. All right, so this page you're familiar with. So now here we are right here. And I want you to pay close attention to what I'm about to say. First of all, number 1, with the written assignment, voluntary of confession, this is the rubric. And these are the things I want you to do in the rubric. Explain what makes a confession involuntary, including reasons that you discover through research, not the textbook and not other textbooks, but research sources. Find and summarize a case where confession was held to be involuntarily given and explain the court's rule holding. There are many cases out there. Try to stay with United States Supreme Court cases. Use proper case citations. You know how to cite cases because I've already told you pretty much from your previous written assignments, where, for example, when you cited the Map versus Ohio, you had the name of the case, and then you had the page number where it started, then you had US, and I'm sorry, the volume that it was found in, followed by US, followed by the page that you find it on, and then the year in parentheses afterwards. And then make sure you do satisfy the APA requirements. We'll talk about that in just a minute more. Now, pay attention. Do not pay attention to this. I couldn't take it out, but the course project is no longer the written assignment because of COVID-19. This is the assignment that you're going to do, that I drafted and created. And I gave you a lot of material I'm going to show you in a minute. So your rubric, and make sure you, of course, have your cover page, your citations and references, but you're going to complete research on one or more of the cases provided. You'll see See, I did something for you that a lot of the people who put these courses together didn't do. I actually found some cases for you and provide details of at least one exception to the exclusionary rule and how it applies to the Fourth Amendment. You'll get 45 points for explaining whether you think that the exclusionary rule is good or bad for criminal justice. Don't just give me a short answer. Elaborate on it, okay? Provide something that maybe support what you say as well. And then, of course, then the APA requirements. Now that's for week 5. So that is the assignment. You're going to see that just a few minutes when we get to the uh, announcement anyway. And then, of course, our live lecture next week will be the last one. Okay, so let's get over here and look at what's on this side here. So let's look at the week 5 announcement and you'll see exactly what I was talking about. So in the week 5 announcement, which I've updated, we're going to deal with the suspect's rights. And this is, I spent, oh God, probably 90% of my career dealing with this in a defense attorney capacity. And so the rest of it was split between being a police officer and investigator, and then being a prosecutor. But that was local deals. So I've provided to you the chapters 10 and 11 PowerPoints, and then we're going to deal with the activity rights of suspect. The discussion assignments are 2. The first one is taking the 5th, which you should know what amendment that has to do with, and the right to an attorney. You should also know what amendment. By the way, anybody know what amendment the right to an attorney has to do with? What's the amendment? Which amendment? Okay, the 6th Amendment. That's it. So the 6th Amendment, and one of the famous cases that you will discover, just kind of helping you out a little bit, sharing a little information, is a famous case called Gideon versus Wainwright. And I have a video that I have that I, if I had a residential class, I would show it. It's about an hour and a half long, but it is very interesting. Henry Fonda, the late Henry Fonda, played Gideon, and Gideon was not a very sophisticated guy, and you can study history on that, but that's the leading case. And then there was another case that came after that, that Escobedo versus Illinois. I'm kind of helping you out a little bit there. So anyway, we'll talk about that too tonight. And then finally, so you know your initial posts are due tomorrow night, and you know your reply posts, they're due on Saturday night at 11:59 p.m. Central Standard Time. Finally, be sure to complete the written assignment, voluntariness of a confession that I just shared with you, and then your project, Fourth Amendment course project, exclusionary rule. So if somebody says, I thought that, no, you thought nothing, don't worry about it. This is the assignment. And you need, if you looked at the lecture, you would know that that's the assignment. And if you read the announcement, then you know what my motto, adversity to springboard to success, is all about. You will see if you go, and I don't know if I fixed this, but I'm gonna check to see if I did. But if not, I will. Course calendar. I tend to not recall fixing it, but let's see, we'll see. So anyway, your reading assignment is in here, and then your live lecture, which is taking place right now, and then your initial posts tomorrow, and then your reply post Saturday, and then your written assignment. Let's see what I did with the Fourth Amendment. See, I gotta fix that. Give me a minute. Okay, let's say I think it should be fixed now. Let's see. Yep. So the exclusionary rule. So that's your written assignment there for the 10th. I know it's Mother's Day, but you get your assignments in before. But that's when it's due. All right. So anyway, and then of course next week we'll do our final lecture on the 11th, and you'll have all the way until, like you normally do on Sundays, to get your assignments done. There's nothing different because this is a 6 weeks course. If 6 week course is a 5.5 course, your course would end right here. That's the 5.5, but you guys go all the way to the 17th. All right, so there's no misunderstanding. So now let's go to the module itself. I really enjoy dealing with suspects' rights. I was paid a lot of money to represent people with that. And it's interesting because as a lawyer, I was paid by a few police officers who became charged with crimes, and they were suspects, which was most interesting because usually they're not the suspects. And the way I met one of those police officers was he was a witness in a case that I represented an individual who was actually acquitted, and I caught him on the stand um, sharing information that wasn't true. Well, basically, it was kind of true, but he got nervous and he messed up, and he provided the information, and so the jury discredited him pretty much in their minds. That's what they said after the case was over. But I won, so he stuck around and he said, "You have a card." I said, "Yes, I do," and I gave him a card. Well, it was sometime later, maybe even about a year, he got in some trouble. And guess who he called? Yes, he called me, and I represented him. And I guess what? I got him acquitted, and he got back to his job and everything. So, I was pretty good at doing that kind of stuff. So anyway, disregard this. Disregard this. They were supposed to have taken it out, but they did not take it out. But disregard this. This is, I'm going to see if I can, yeah, I'm going to see if I can delete it. I'm going to try to delete it. Preserve scores. Okay, good. So that's what I want to do. So it should be gone. Okay, good. So now you won't see it because it's gone. All right. Now, so the written assignment is this and the discussion. So now where is the other one? The other written assignment should be in here. I don't know why it's not in here. So because it's been deleted. Okay, let me go back because I got to add it to it. Well, anyway, here's the deal. I've already posted it on here, course home. Let me see if they let me add it. Yeah, here it is right here. This is week 5. I'm gonna try to add it to the module itself. Okay, here it is. I'm doing editing right in front of you guys, but let's go to the here. Okay. And they should let me add an assignment. It's not letting me. This is what I hate because PSC was supposed to fix this. Let me see. Okay, here we go. See if it lets me. Oh, it may not do it. Oh, I have to do it this way. There we go. Week 5. Alternate. Fourth Amendment. Just as you see how we do stuff. I'm just trying to get it so that I can make sure that everybody got it. Okay, now. Okay, it should be submitted. Should be in here now. There it is. Okay, let me make sure that it's available to you. Okay, it is. So everybody can see this in their module. You can see it now? Perfect. Yeah, PSC didn't do what they were supposed to, so I had to do their job. I should go and get some of that money in there from them. But anyway, the one thing that you have to do as far as this is concerned, let's go back to the rubric so we can look at it. Well, you already know what the rubric says because I forgot the rubric is not built into the grade book for this course purposely. All right. So any questions about the voluntary of a confession? Any questions about that assignment? Any questions? Okay. Okay. What about you, Adam? Any questions? Okay. All right. So it's pretty clear based on the rubric as well. Remember, both of these have rubrics. And then your discussion assignment, taking the fifth, which you already know what amendment it is because it tells you. And you're going to deal with these issues here. And then, of course, the Sixth Amendment. Um, now they talk about the Sixth Amendment and dealing with people like OJ who, have more money to hire uh, um, attorneys. But anyway, so you some point in there, you should be aware of the case I just mentioned, and that's Gideon versus Wainwright. Okay, if you don't use that in there somewhere, I'm gonna think something's wrong here because, and I told you the Escobedo case. So now the course project, which in this case, it doesn't really have the addition of the due date, but I will put it in here. I will make sure we have it. Oh, they won't let me. But anyway, you know the due date. All right, just because I had to do it the way that they didn't do it. So here I gave you a lot of information. So what you're going to do is I gave you the Fourth Amendment and I gave you the 14th Amendment. I had previously sent this to you guys anyway. Did you guys get this earlier when I sent it to you? A couple of weeks ago or a week or so ago? Did you get it? Okay. So anyway, contemporaneously here, so Weeks, one of my students and I had a nice discussion about this. He's not on with us today. Um, So the key thing is that, let's see what she said. She said something about, let me see what the chat is. Go down here. In one case I have in mind, there was a persuaded approach the interviewing officer did while conducting suspect's testimony when getting the suspect to admit to the crime by alleging that we will talk to the DA and get you a better deal. No comment on that. I know how that works. Yeah, that happens. You'll that's a technique that comes up sometimes. So anyway, I give you a little history up here. All of this is information to help you, and this is history right here. And then these are landmark cases that normally you would have had to research yourself. And the reason why I did this way is because of the fact that it cuts down on your time that you need to find information, but you do need to take a look at one of these cases, or maybe more. But the one that's very interesting, Riley versus California. Does anybody know about Riley versus California? Anybody know anything about Raleigh versus California? Okay. Adam, know anything about it? Shakira? Okay. Well, let me tell you just a little bit. And yep, that's it. That's it. She got it. It's the cell phone case, which is a contemporary. That's why it's very recent, and you're going to find that very interesting. I remember when I was teaching this course at in a few quarters ago. That was the most interesting case, But yeah, so that's U.S. Jones versus Jones is a little bit. I won't comment about that, but yeah, this is the famous cell phone case, and I'll leave it alone from that point because I've already done enough of your work. Okay, and then there are many exceptions, and these are the ones I want you to use. Now, look at my instructions now for the assignment. This is what's in the rubric. You are to research one or more of the cases that I mentioned. Pick at least one of these exceptions and prepare a 2-page paper or more, but at least 2-page paper, double spaced. And in the paper, provide the details of the exclusionary rule and how it applies to the Fourth Amendment. Present your position as to whether you think that the rule is good or bad for the criminal justice system, and support your position using the research you performed to complete this assignment. Check your grammar, spelling, and use the APA format. And then the rest of it is standard how you submit your assignments. This is probably one of the easier assignments because I gave you, I didn't I gave you the cases, the leading cases, and you can pick you can pick these cases. I recommend you stick with these cases. The reason is because these are landmark Supreme Court cases that deal with the exclusionary rule and helps you to understand and that kind of stuff. Any questions? Okay. Junior, any questions? Shakira, any questions? Okay. So anybody else who is not here on the call, just make sure that you clearly understand the information there. So um, that's it for the assignments, and then of course your live lecture phrase, which we're going to give you at the end. All right. So let's talk about what's happening with the suspect's rights. Okay. And we won't be able to get away with this lecture without speaking about the famous Miranda case, which I'm going to have some inside information for you. A very interesting thing that I learned about it while I was in law school. Some of you might already know what I'm going to say regarding that because of taking criminal law with me, because I talked about it then. So we're going to talk about the rights of the suspects. Then these are the assignments that you have. Remember, disregard this. You're going to do this and that. So they wouldn't let me. I didn't. Well, I could have amended this, I guess. I guess I could have amended that too. Um, let's see if it lets me, because sometimes these systems are really pretty funny in terms of, yeah, yeah, this one is pretty weird. So I'm gonna just cancel that. So anyway, you already know um, what to disregard this. So anybody who doesn't get this, that means they didn't listen to the lecture. All right. All right. So let's talk about the rights of suspects. Now, I'm smiling because this famous case, and by the way, this is a proper citation, 384 US 436, 1966, which means that volume 384 of the United States Supreme Court reports at page 436, you will find the case of Miranda versus Arizona, a 1966 case when it came out. So as you all know and have heard almost all the time, the famous Miranda versus Arizona rights were created out of this case. And that's where it says Miranda warnings. And they are very simple. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed to you. So the key thing is that in this case, the United States Supreme Court took the time to make sure that people understood what they were doing when they spoke. And it had to be, as it says here, in the language given to them that they understand it. Now, what many departments, police departments did, including the one I worked for, and even today, is that they give the police officers a little card about the size of an index card, and they carry it with them with the Miranda warnings on it. And generally, to protect themselves, they will read straight from that to make sure, because if they leave off any of the rights in terms of verbally giving it, then an attorney can come back and have the case thrown out, because every element had to be right with them, and they had to understand them as well. Now, in this case, well, I'll go ahead and talk about this, and then I'll tell you about what I'm going to say in a minute. And this goes to the Fifth Amendment, by the way. This is one of the Fifth Amendment. This is one of the leading Fifth Amendment cases, by the way. So, as I want to point out here, they gave some good bullet points. Voluntary intoxication is not a defense to voluntariness. We already have, I think we've either discussed it, or I discussed that in criminal law. This means that if you get drunk on drugs prior to being arrested, you can't later claim that you did not voluntarily waive your rights due to intoxication. But if you were drugged unknowingly, then you can argue that. So everybody got that? So you can't come back and say I was drunk or high and made myself high. And then the second bullet point is officers can lie. That's where I get to what you were saying, Shakira. Can lie or tell stories to the suspect to get them to talk. For example, an officer can tell the suspect that if he is honest with the officer and tells the officer everything, he will get a chance to leave custody, even if they know it is not true. And that goes to also what you had commented about, Shakira, as well, that they will try to cut a deal with the prosecutor for you. No, no, no. They can do that. And so when it says silent, it means silent. Don't Don't go for the okie doke. That's what I used to tell all my clients. Then it says the rights can be invoked at any time during the interview, and the officer has to stop. So let's say you at first say, okay, and you start talking. Then you say, I'm not talking anymore. I don't want to talk anymore. And those magical words, I don't want to talk anymore. It's just like somebody saying on the phone, do not call. Well, automatically by law, that goes on the do not call list. Well, this automatically kicks in the officer's responsibility to not question that individual anymore. Not even to come back later and say, did you change your mind? No. I have won cases like that. So a suspect must actually verbally, though, say this. The suspect silence is not enough to be considered an invocation of the right. So what that means is that just because you don't talk, you have to say specifically, I don't want to talk to you, or I want my attorney. Boy, if you say that, it's over, people. It's over for law enforcement. And the reason for that is to protect the rights of individuals. And then we start to move toward the Sixth Amendment and things of that nature. A suspect must be in custody in order to receive Miranda warnings. How do you know if a person is in custody? Anybody in this class tell me, how do you know if you're in custody? How do you know? How would one know? Nope. Doesn't have to be in the police car. Anything else? Been told? Been told what? You're under arrest? Yeah, but there's something even more. Uh, you are a suspect? Nope. 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 No, 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 no. You are under arrest? Yeah, kind of closer. They should say you're under arrest. They don't have to. They don't have to. Been told, officer will tell you under arrest in the police car. Nope. It's something very simple. Any other final guesses before I give it to you? It's very, very fundamental. Nope. You don't have to be handcuffed. Nope. Okay. Can I go, officer? No. Then in that case, you're custody. If you're not free to go, just remember that, people. That's the key. If you're not free to go, just always remember that. Yes. Yeah. Well, the whole obligation is that you're under arrest when you're not, your liberty is taken away. If you took my my constitution, not my constitutional law, my criminal law class, that's one of the things that we talked about. And so it asks exactly what is custody, and in these whole bunch of cases you discover that it means you're not free to go. Yeah, a lot of students think that, oh, you got to tell them they're under arrest. Well, yes, that's true, but if you question somebody after they are not free to go and you didn't give them Miranda warnings before you question them, I'm filing a motion to suppress, which means that the judge is going to say, you told the person, or the person wasn't free to go, and you questioned them. Did you give them Miranda? No, I didn't tell them they were under arrest. Ah, you're best up, officer. You officer. I mean, if your chiefs are all in there, they're gonna put their hands over. You're gonna have a probably, you might get suspended or something. But the point of the matter is now you got that. Everybody got it. Never forget that. Always down the road, you're gonna need to remember that as a police officer, law enforcement officer. Now, let me tell you something about the Miranda versus Arizona case. If you take the time to read the whole case, you will discover in the footnotes that there was a book called Interrogation and Confessions, and it was written by a guy by the name of John Reid, Reid, and Fred Inbau, Inbau. Fred Inbau was known as Freddie the Cop at Northwestern University because he always um, stood up for law enforcement. He was my professor in my first year of law school at Northwestern University in 1975. And when we studied the Miranda versus Arizona case, he said that he personally was offended by the United States Supreme Court attacking what he, as a co-author, did because these were techniques that the police were using. And so as a result of that, he said that anytime a case came up before the United States Supreme Court concerning possible Miranda warnings, he would submit what we call an amicus or friend of the court brief on behalf of, I think it was the National Association of Prosecutors, as reasons why Miranda versus Arizona would be overturned. That was his personal vendetta. Professor Inbau died. He's passed away now. I don't remember when he died, but I can tell you that all the years that he was professor at Northwestern, he shared that with all of his students. And let's see, I'm trying to pull up something for you. Here we go. Professor Inbau, he was 89 years old when he died. Yep, yeah, he was 89 years old when he died. I think he died in May 28th, 1998. So it was many years after I had graduated. But he wrote many articles that you can find where he personally talked about the United States Supreme Court decision of Miranda versus Arizona. Now, this is something that you won't learn from any other professor because I have some inside information. Very interesting, his approach that he had as to reasons why. He didn't think that the police should be shackled by giving these, what do you call, criminals. And we said, well, Professor, were they criminals, really? I mean, because they hadn't been proven guilty yet. But anyway, his whole philosophy was pro-police. So he didn't think that they should be told the right to remain silent. He didn't think they should be given the right to an attorney. Listen to me. I mean, so he was pretty hardcore and it's from the old school. So I thought I would share that information with you. And that's something that, like I said again, so Miranda versus Arizona, Professor Inbau, we used to tell him it's going to still be good law. I remember when I was a lawyer and I was talking about the case several times with even some judges. I mentioned I went to Northwestern and Professor Inbau. They said, oh, buddy, everybody knew practically, particularly those who were graduates of Northwestern, his position, because he wrote it in articles and law journals and things of that nature. So anyway, so that's how the Fifth Amendment Miranda versus Arizona right works. So any questions about that? I mean, everybody knows that. Any questions? Okay. One day maybe someone can do some research on that, whether they think the Miranda warnings are adequate. Should they be taken away? Should they be changed? Should some of them, or should there be some additions made to it? Very interesting project that someone can consider for the future. So now let's talk specifically about what the Fifth Amendment says. It says um, right here, and no person shall be held for capital or otherwise infamous case unless a presentation or indictment. So it's by indictment or by grand jury that individuals are charged in criminal court cases, aside from juvenile cases. And it talks about um, nor shall a person be subject to the same offense to be twice put in jeopardy of life. That is what we call double jeopardy. Nor shall it be compelled in any criminal case to testify against yourself. That is why in criminal cases that the witness, that the defendant is not required to take the stand, because the burden of proof is on the prosecution to prove beyond a reasonable doubt that the person is guilty of the offense, and that the defendant does not have to help them by testifying. Anybody who knows anything about the O.J. Simpson case, which I talked about in one of my classes, is O.J. didn't testify because what happens sometimes is that there are individuals who may have a propensity to want to have what we call diarrhea of the mouth and keep talking and volunteer information that they shouldn't. Or another very good reason is because the individual is a person who has already been previously convicted, because you should be aware that the trier of fact, particularly the jury, is not entitled to the information about the criminal history of that individual, um, because unless that individual takes the stand, and then the prosecution can use that to impeach the individual. Because what we do is we take defendants and we uh, make them look like good people, put them on shirts and ties, get them a nice haircut, shave, and all of that. Maybe even put them on glasses if they wear glasses and those kind of things. But the point of the matter is that if that person gets on the stand and then they've been convicted of a crime, then they can be asked about that. And then what you're doing now is you now have given the trier of fact, the jury generally, reason to believe that you probably did this if you did that. So it cuts against you. So it's a tactic that we defense attorneys, I can tell you many a times I had clients that wanted to testify, and I told them if they wanted to testify, they were going to get another attorney, because if they did, they were going to shoot themselves in the foot, and I wasn't going to be a party to that. Nor deprived of life, liberty, or property without due process of law. That means what it says, that you have a right to face your accusers, receive, of course, the written process by information or grand jury indictment about the charges specifically laid out against you, and the opportunity to defend yourself and present a defense. So against the charges. Let's see what Katie said. I'm surprised there isn't a rule against using past. Well, it is. No, what I just said though is that if you get on the stand, what it is, remember what the only reason that a defendant would get on the stand is to try to uh, say they didn't do it or they didn't commit the offense, but their propensity for telling the truth could be challenged by bringing up their past criminal history. You see what you see why that works that way? Okay, so that's why we criminal defense lawyers made the decision in many instances not to have our witnesses, our clients testify. Do you know I have had cases where the state has put on witnesses and I didn't have any other witnesses, and I have rested after the state's case. I sure did. And I won some of those. Yes. Yes, I have. So the point of the matter is that so the Fifth Amendment says that you don't have to testify against yourself, and you do have a right to due process, and private property shouldn't be taken without just compensation. That's where we get into the forfeiture laws. You guys are familiar with the forfeiture laws. If you took my criminal law class, you guys familiar with the forfeiture laws? Anybody? Well, forfeiture laws are very straightforward in that, in the event that you, for example, take your car and commit a criminal offense using your car as the mode of transportation, or putting drugs or whatever in it, that vehicle can be seized, and it goes into a hearing that is not a criminal hearing but a civil hearing, and by a preponderance of the evidence, that if it's determined that that vehicle was used, or if that property was gained using ill-gotten gains, such as drug money or some other illegal money that you got, then in that case, then the property can be taken for public use. Anybody ever seen a Dare police car? You know who Dare, about Dare, right? The drug education. Well, most those Dare cars come about from cars that were confiscated, and they were taken, used for public use as Dare, as police cars. You know those plain police cars that stop you and that you don't realize it's a police car until it's too late? Everybody knows about that? Yeah, that's how a lot of those cars end up. They don't just go out and buy these cars. No, they're unmarked ones. They'll take them, and there could be like vets, a Corvette. I know one of my friends. Uh, yeah, you can lose your car in a DUI. That's another way of what I just said. You violated the law. So that's what that's all about there. All right. And I've represented some people successfully because, like, for example, one of my clients took his mother's car without her knowledge. They took the car, it was her car, and she had nothing to do with the offense. So I represented her and got her car back to her because they couldn't take it because she wasn't part of the crime. Uh, how difficult is it to defend someone when you know they are guilty of the crime they are charged with? Okay, let me give you a little education. I never represented individuals who were guilty of the crime they were charged with. Start with. They were charged with the offense and presumed innocent until proven guilty. So therefore, there are evidences that maybe excuse an offense. There's like self-defense. I had a bunch of those self-defense cases where, yeah, they killed them, they shot them, but that they did it in self-defense. So they were guilty of the offense, but the law says it was justifiable homicide based upon all the circumstances. I didn't have any trouble with representing individuals that were so-called bad people, because you know why? If the law enforcement police did their jobs correctly and did them well the way they're supposed to, follow the constitutional rights of those individuals, and did a very good investigation without botching it up, like the O.J. Simpson case. If those of you who know about how I think, did we talk about that in this class? O.J. Simpson. We didn't talk about that, did we? I think it was in my one of my other classes I taught, realities in criminal justice. But the O.J. Yeah, that was last quarter. Yeah, so you were in the class. So the point of the matter is what messed that case up was the police work. So my whole point in a nutshell is that no, like I said, when I represented that police officer who, and that was just one example, that he was happy that I was like that because he was in trouble at that time. So does that answer your question, Michelle? What do you mean to a degree? Elaborate on that. Give me some more. Well, that phrase that Johnny told me personally what that was all about. Sometimes people are guilty. How? Who determines whether people are guilty of a crime? That's one. Who else? Well, you see, you'll be a good prosecutor. Hopefully, jury. It depends. What the jury hears, the jury makes a decision. But there's one other way that you determine guilt or innocence other than the jury. And what is that? Most of us defense lawyers don't use it. No, the judge, the judge, or the jury. That's it. It's simple as that. Judge or jury. Facts are relative. So that's the key thing that you need to be aware of, the way that the system operates. All right. So as a defense lawyer, when I'm representing someone who has the under the law cloaked with the presumption of innocence until proven guilty by beyond a reasonable doubt by the judge or the jury. I'm really look at this and laugh, I think. Is it a Hollywood movie thing when someone did the crime and got a real lawyer who pulled off? Yeah, kind of like, you mean like Legally Blonde? Sort of. My cousin Vinny. Oh, you have to see it then. And my cousin Vinny, it really is a good one. We could use that in law school to teach people how to what we call impeach witnesses. That is what I did with the police officer to catch them not telling the truth. So, so the answer to the question is that no, it has happened, but we don't have nobody like, for example, if you guys are too young to know about Perry Mason, there was always somebody in the courtroom who did it. But in Legally Blonde, if you remember, the person who did it was actually not the woman that they were representing, but the daughter of the person who was shot because she was thought she was shooting the woman who was the defendant at the end of the movie. Stuff like that, yeah, yeah. Perry Mason was pretty awesome, but I that was when I was a kid with my vision of a lawyer. But you know, but yeah, as I said, facts are relative. Can you explain on that? Well, it means that facts are determined by the trier of fact. The trier of fact, the judge or the jury. I feel like that's a lawyer's phrase. Nope, it's not. In a criminal justice case, the trier of fact determines the innocence or guilt of a person. No, the second wife was not charged. Yeah, okay, the second wife was charged. Yeah, but she was innocent because the evidence she impeached the daughter on the stand, and that she admitted that she did the crime. That has happened, but it doesn't happen that blatant a lot of times. So very rarely does that happen. I've had some things close to that, but nothing as close to, exactly like that. That's TV. So anyway, back to what we're talking about, because we got to talk about the Sixth Amendment, and we're over our time. Is that when a person takes the Fifth, what they're saying is that um, anything they say could incriminate against them. So if you ask a witness a question on the stand, they might tend to plead the Fifth. And when they say plead the Fifth, they utilize the circumstances of what you learned about the Fifth Amendment and not incriminating themselves. And so if they say something or answer a particular question, they may um, be tending to be convicting themselves like that young lady did in Legally Blonde or any other situations. So so when a person pleads the Fifth, it says usually done outside the ears of the jury and prior to testimony is given. Uh, if it's in the middle of a legal proceeding, a judge will recess the jury. Uh, and if the judge agrees that he will incriminate himself, then the other side may request a mistrial and have all that information stricken. So the point of the matter is the pleading of the Fifth normally takes place outside of the hearing of the jury. What's interesting about it is that, as I said, there are two triers of fact, the judge and the jury. The judge still has to make a decision, and then it's supposed to be professional enough not to be influenced by it. And that's just how that works. So that's it on self-incrimination. Any questions before we conclude dealing with the Sixth Amendment? So you got to remember something, guys. The Constitution is designed to protect people from themselves, and that everybody's entitled to, as we said, due process, and they're entitled to representation. And so now, based upon the Sixth Amendment, it says one of the points is the right to request counsel when they are in custodial interrogation, and must be advised according to the rights that we just talked about. Well, under the Sixth Amendment, then the person, as it says, has been formally charged with a crime. A prosecutor may not speak to the suspect or defendant without the lawyer present, whether in or out of custody. Now, remember what happens once you've been formally charged. It's kind of funny to say out of custody. Well, generally, but what does that mean if you're out of custody and you're a defendant? What does that mean? Anybody know? Take a guess. How are you out of custody if you're a defendant? There we go. Perfect. Yes. Bail. So you're on bail. So you're not in custody anymore, but you're still afforded, you have your counsel and they can't come to you. Perfect. 2 thumbs up for you. So, but yes, that's absolutely correct. And it tells you here, right here, it says, for example, if Officer H brings Sam to the station to interrogate him because he's a suspect in a recent retail theft, the officer must advise Sam of his Miranda warnings. If he invokes his right to counsel, he got to wait until the attorney before continuing. If Sam is held in jail and later formally charged for the retail theft, Officer H cannot question Sam again without the lawyer present. And so that was, like I said, whether they're in custody, can't make bail, or out of custody. Very good. All right. Now, it says, however, though, let's say Sam was released and no formal charges were filed. Okay. No formal charges at that time. Not charges dropped, but no formal charges. To interrogate him again at a later date, then the officer would more than likely have to give Miranda warnings again. And then they would have to invoke the right to counsel again. And if Sam didn't invoke it at this time, the court would probably find that Sam's statements on the second interrogation would be allowed into evidence. Of course. Of course. Of course. It is. It's all of what you said, Junior. However, it's a constitutional right. You're right. Of course, you're taking the fifth because you're hiding something. Because if you say it, you're going to be charged with a crime. Okay. So yes, that's an absolute thing. I don't have anything to think about it. It's part of the process. It's there to because the Constitution says we don't want people uh, incriminating themselves. We want the state to prove them guilty. We don't want them to help the state. But yeah, it looks suspicious, of course. But we as lawyers have a good job to make sure that we make it clear to the trier of fact, the jury particularly, that just because the person pleads the fifth, or and see when they plead the fifth, remember it's generally outside of the hearing of the jury, then that information is generally not given to the jury. Some people, yeah, well, I just said that earlier. Some people just talk too much and make themselves look guilty even if they're not. Yeah, because they get tripped up and people get nervous, just like police officers do. Like I said, I've been able to successfully do that. Yes, I was very good at that. Okay. So anyway, if a suspect is in custody on one charge, and while that charge is pending, the police are investigating him in another crime and they bring him into the interrogation room to ask him about these new crimes, the suspect must be given new Miranda warning. The key thing is the individual give the warnings on any stuff that they already that comes up subsequent to that, or new charge possibilities. Suspect can also invoke his right to counsel, have a lawyer present. However, the police may not question him regarding the case that's already pending. So, and then it goes down here. And last thing is, if you're charged with retail theft and you're brought into custody on a domestic violence case, the officer must advise the person of the Miranda warnings regarding the domestic violence case. But they can't ask about the retail, since the Sixth Amendment protects Sam and cannot be questioned without his lawyer present on the matter. So the history of that is Gideon versus Wainwright and Escobedo versus Illinois. Any questions before we adjourn? Okay. Before we adjourn, any questions about final questions that you might have thought about it concerning the assignments? You're all good with that? Okay. 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 Did you not know, I'll say this in final, um, there are attorneys who were prosecutors and then they left the prosecution office, or they were judges and they became defense lawyers. Did you know that? Yeah. Yeah. Yep. Seen it many a times. And then vice versa. I've seen defense attorneys become prosecutors and become judges, and they're more favorable to the prosecution than the defense. The theory on that is, has the clients admitted to you that they are guilty? Yeah, yeah. Oh, yes. Did I have to tell somebody that they admitted to me? Does anybody know? No, that's not the reason. Do you know some responsibility that a defense attorney has to their clients? It's called the what? There we go, Junior. Attorney-client privilege. Yeah, because we want people to be able to. That's why if you're in the corrections class, you would discover that if a person comes to visit inmate, that they can be heard by guards and everybody else. But when the attorney comes, you can't do that. You're not allowed to do that because of the attorney-client privilege. So, yep. So, yeah, yeah, that's, yeah. Yeah, when they say they're guilty, they're saying technically, yes, I did it. But in many self-defense cases, let me give you a quick one. I had a young man I represented in my very first case, and some of you may have heard me talk about this in my other classes, is that he um, was holding a crap game, and these two guys came in the crap game, and they let him in, and they went up the stairs, and he turned to lock the door. Well, the guys got to the top of the stairs, and they announced that they were robbing the place. Well, they had guns. My guy had a gun in his waistband. He got his gun and took a couple steps up the stairs, leaned and shot both of these guys, each one, bam, and they each hit the ground. Then he ran up the stairs and emptied, they were face down. He emptied his gun in their backs. And I knew all of that. I was able to win a self-defense case. And I'll tell you why, because I don't want to belabor the time. I was able to prove by the medical examiner's report that the shots that were fired by my client that killed the two guys were consistent with them facing him with their weapons, and that when he went up and shot each of them in their backs, they were already dead. And it was quite clear of the cause of death and the angle based upon the medical examiner's report. And he was found not guilty by the jury. Yep. He never testified. You know why I didn't have him testify? Because he was already out. No, because he was already convicted of a criminal case previous to that. And that would have been used against him, but it never came up because I didn't put him on the stand. So anyway, those are just some of the things. So yeah, it's a very interesting thing. Yeah. Well, when you begin to study the system, you begin to understand a lot of things about it. And somebody says, am I bothered by what happens with people? Well, the history of that young man I just told you about, I tried to turn his life around. He went down to Texas. He got in trouble with another case, but I told his mom I wasn't going to take her money to represent him down there because she was such a nice lady. So he ended up doing a little time down there, and then came back up here. And then he went into a restaurant to eat, and some guys came in and with hoods and told everybody to get out, and they shot him and murdered him like St. Valentine's Day massacre. So he's dead. So here's what I used to always tell these guys that I represented that were involved with crimes and they were found not guilty. I had gang members and all that stuff. I used to tell them, if you don't change your life, next time I see you, you're going to be horizontal. And I had several times where students actually, I went to their funerals. So I believe seriously, you know, well, this used to be an 11-week class, but the school's now doing 5.5. Take another one of my classes, the junior, and then you might, let's see, you're in, since you guys are in a bachelor, if they bring evidence back, and I might teach that, or realities in criminal justice, I'll be teaching that as well. So, but yeah, okay. Well, guys, I'm sorry I held you over, but you all were Sharon, you asked some really good questions and things like that. Um, any ideas about the keyword phrase? That's you're in the ballpark. Anything else? It was. Thank you. Any other suggestions? Katie is right in the ballpark. What amendment is involved with the Miranda warnings? It is. Kind of, yeah. But what's the overall? What's the amendment? Pretty much only there. Okay. You scared me there. Yeah, it's the Fifth Amendment. That's the key phrase. Give me that. Give me the Fifth Amendment and you'll get your points. All right, guys, I'm going to say good night to you. Keep me in your prayers. Tomorrow I have to do the service for my brother-in-law that passed, and I will be catching up on your week 3 grades this week. And so it's been a challenge dealing with this situation. So and then my basement flooded. I'm actually upstairs on the loft in my area until they get my basement back in order. So good night, guys. Stay safe, and I will be seeing you next week at the same time. So good night. Hope you enjoyed class tonight.